Hey friends, Peggy Hall back with you from thehealthyamerican.org. And I am going to be giving you an update about my lawsuit against the Orange County Board of Supervisors. Many of you have partnered with me in this fight for freedom and truth and justice. Tomorrow is going to be November 29th, and I am going to be participating in a deposition. A deposition is where the attorneys for the defendants are going to be, or the respondents in this case, are going to be interviewing me under oath, and they're going to be asking me all manner of questions to determine my, I guess, trustworthiness or reasons for suing the county. So this is going to be very interesting, and I'm going to be attending the actual hearing on December 1st. And that is going to be on Thursday. And that is where the judge ideally is going to issue a ruling as to whether or not the Orange County Board of Supervisors has to follow the law. That is the nuts and bolts of this lawsuit. So what I want to do is just speak briefly about the update, what I've done so far. And I want to thank all of you that have partnered with me, with your support, with your prayers, with your moral encouragement, with your questions, with your links, with your videos, with sharing this information. And I want to explain what this lawsuit is all about and why it is so important. So let me do this. In a moment, I'm going to share my screen. And I just want to let you know that this is not a criminal lawsuit. I am not suing the county for any money. I am actually requesting what's called a writ of mandate. And you know that word mandate has been used for the last almost 3 years by governors, by the president, by health officers, by your boss. And unfortunately, that word was taken out of context and it was used inappropriately. And I've done a video about the language and how they've stopped using that. And now they use words like protocol, strategy, policy, requirement, measure, rule, because the word mandate, as I have pointed out again and again and again and again, is being used incorrectly. Only, to my understanding, a judge can issue a mandate requiring either someone to take action or to cease and desist of a certain action. And here's the basis of the lawsuit. Orange County, California declared a local health emergency in the county in February of 2020. That means we're coming up on 3 years. I've spoken before how even a third grader knows that an emergency is a very limited duration and limited scope. You can't just cast a wide net and have an ongoing emergency. It defies logic. So they are required by law in the county in California. It might be different in your state. In fact, let me show you what this is. I'm going to cue this up so that you'll know exactly what I'm talking about. And I just did a video about the Orange County Board of Supervisors meeting tomorrow, which I will not be attending because I'm going to be in the deposition with the county attorneys asking me these questions about the lawsuit. But they're holding a meeting in order to go over many agenda items. And one of the agenda items is to vote on whether to continue the new health emergency. And I want to show this to you because it's very, very important when it comes to my lawsuit. So let me do this. I'm going to share my screen. And this is actually the agenda for tomorrow for the Orange County Board of Supervisors. And tomorrow, I hope many of you are going to show up. If you'd like to know my opinion about this meeting and whether it's worth your while, please watch the video that I just did all about that. But we are going to go down to agenda item, I believe it's number 37. Here we are. It's number 34. It says that one of the items they're going to discuss tomorrow is to approve the continuation of the local health emergency, which was declared by the county's health officer and by the chair of the Emergency Management Council. I've spoken at great length that the Emergency Management Council in Orange County was only meeting quarterly, and basically they were just filing reports. If there was an emergency that was so dire and of such magnitude, don't you think they would be meeting 24/7 and they would have shifts, or at least meet from 8 to 5, or maybe every other day, or maybe weekly, or even monthly. They're meeting quarterly. That means every 3 months. So that right there is evidence that there is no emergency of the magnitude that they are claiming. Now, here's what I want to show you. The reason why this item is on the agenda is because, and you can do this, you can click through on any of these agenda items and you will get backup information. So I'm going to, at least that's how it is in Orange County. Your county might be different. I'm going to click on that. And here they are using this document as authority for why they have to include this agenda item. This is the basis of my lawsuit. It is this law. There is another law as well, but I'm going to focus on this one right now. And it is called California Health and Safety Code 101080. I probably should have this emblazoned on billboards, on coffee mugs, on t-shirts, because it is of utmost importance. And what it says is that the local board has to approve any health officer's declaration of an emergency within 7 days. And after that, here it is, that the local emergency cannot stay in effect for more than 7 days unless it has been ratified by the Board of Supervisors or the City Council. In this case, it's the Board of Supervisors. The most important part of this law for me is that the Board of, and this is the law that the board is violating, the Board of Supervisors shall review at least every 30 days. They can review it daily. If it is of such dire magnitude, wouldn't they do it daily? Wouldn't they have a daily update by this Emergency Services Council? Imagine that there's a fire or an earthquake or a flood or a hurricane, a tornado. Wouldn't they keep everyone notified 24/7? So this law says that the board has to be updated at least every 30 days or until the local health emergency is terminated. Now, only this board can terminate the local health emergency because they have the legislative power. That is the basis of my lawsuit. It says that once they proclaim they shall proclaim the termination of the local health emergency at the earliest possible date that conditions warrant the termination. It seems reasonable to me. Doesn't it seem reasonable to you? That if there is a bona fide emergency, the local health officer under California law, it's different for every state, has the legitimate authority to call for an emergency and to take any action necessary, and I would like to have a definition for the word necessary and evidence for the word necessary in order to protect life and property. After 7 days, the health officer can't go rogue. The health officer has to bring the evidence to the Board of Supervisors. The Board of Supervisors is to review it, to get testimony from the health officer, and then to determine whether or not it is a bona fide emergency. And they can vote to ratify or approve the emergency, or they can vote to terminate even that 7-day window. So to me, you know, if there's a bona fide emergency, if there's a chemical spill, if there's a fire, if there's an earthquake, well, you know, 7 days is a little bit at the long end of the duration in my view, but that allows the health officer to, and the board and the county and the emergency services to get their ducks in a row. Maybe they needed to call in more first responders. Maybe they needed more fire trucks. Maybe they needed more materials or personnel. It seems reasonable to me for that 7-day window. What seems unreasonable to me is for an emergency to last for going on 3 years, because I've described this many times. There are 4 recognized stages of emergency management. And number 1 is the preparation. You prepare for the emergency. I live in California. I have my earthquake kit. I have my bug out bag. I've got my generator. I've got extra water, extra food. I've got an emergency plan, where to meet my loved ones. That is called the preparation phase. Then you have the conditions of the actual emergency. The earthquake happens, the power goes out, your windows break, everything falls off the shelf. You were away from home and your loved one was somewhere else. So the emergency is limited duration. And then you pick up the broken pieces, you meet and you find your loved ones, you use the power generator. Is everything back to normal? No, but you're no longer in the emergency. This is called the aftermath or the recovery stage. Now you pick up all the broken pieces. Now you try to get the water and power back on. You might be, cooking on your camp stove that you prepared and making the food, emergency food that you had aside. So the emergency itself is over, but you are recovering from the emergency, and that's stage 3. And stage 4 is mitigation. Mitigation is when you assess what happened and then you make plans to improve for the next emergency. Let's say that I didn't have enough water, and I would assess the status, and I would say, oh my gosh, I didn't have enough water because I thought the water would be turned back on more quickly after an earthquake. So next time I'm going to have more water. That's called mitigation. You prepare and you plan based on what you went through. Friends, where are we? Where are we in the cooties emergency? Are we in the actual bona fide carrying out of the emergency? Is 3 years long enough to get more personnel and PPE and water, so to speak, to use a metaphor? It defies logic. Luckily, these laws were written in the California Emergency Services Act. This is the exact law that the county is required by law to follow. Are you ready? During an emergency. That's the kicker. They cannot use the objection or the defense of saying, well, it's an emergency. This is the law that was written for what you're supposed to do during the emergency. So what is my lawsuit about? My lawsuit is requesting a court to require this Board of Supervisors to follow that law I just showed you, 10-10-80, because guess what? They're not following it. They are not only not following it, and let me explain what that means by not following it. They're not holding the meetings. Back in, oh my gosh, it was like a year ago, because I filed my lawsuit a year ago in October. They went on the record to say, we are no longer going to review the data about the local health emergency. We're just going to wait for the governor to tell us what to do. Then they went on record to say, if we cancel the local health emergency, we'll no longer get the money. All right. That's called fraud. Fraud is the misrepresentation of information materially for gain. So they are misrepresenting to the public, we the people that live in Orange County, we are their electorate. They are supposed to follow they're supposed to follow us because they are to represent us. And thousands of us went before that board, meeting after meeting after meeting, when they did put it on the agenda. And frankly, I think they were just tired of having us all show up to give them our opinion. Which is it? They're supposed to, they are required. It is a legal obligation. They have a duty. It's called a ministerial duty to put this on the agenda and to receive data from the health officer to determine whether or not to continue this 3-year emergency. Don't you think they would be fascinated? Don't you think they would be eager to find out if it's still an emergency or not? Don't you think they would want the data to find out how many people are dying of this disease and how many hospital beds are available? Don't you think they would be eager to get this information, regardless of that the law requires them to get the information? But oh, no. They said they're just not going to listen to it anymore until the governor tells them what to do. Friends, this is the basis of my lawsuit. It is to preserve and defend our constitutional republic, our form of government. We are not a democracy. We are a constitutional republic. Don't fall for those that are trying to hit you over the head saying that we are a democracy. And there are so many that are falling for that. We are a republic. A democracy is not restrained by a constitution. We are restrained by constitutional laws, which is a whole nother topic, because what was going on with these orders were unconstitutional as well, or what was going on was unconstitutional. But the point is this: we have 3 branches of government. We have an executive branch, which would be the mayor. It would be the governor. It would be the president. The president and the mayor and the governor have zero legal authority to make law. So for this board, which has the legal authority, it's a legislative body. It can vote on who to give the money to. And I just did a video about that where they're giving the $3.4 million to track your pincushion status. They have the legal and the legitimate, not only authority, but duty to create the laws or to vote on them. The governor doesn't have that authority. So to tell us in public at a meeting that we're not going to put this on the agenda any longer, in defiance of California Health and Safety Code 101080, which says they are required to review it in public, by the way, every 30 days. Not only did they say we're going to ignore that law and that duty that we have, bound by law to follow, if that's not bad enough, now they want to give over their legislative power to the governor. In essence, they want this to be a totalitarianism dictatorship, that the governor is going to tell the legislative bodies what to do. How do you think, what do you think about that? Do you think that is a worthwhile lawsuit? Do you think this is probably the most important lawsuit that you have heard of? This lawsuit, in my view, is the most important argument to make because we have three distinct branches of government. This is like saying that the governor has the authority to make the laws, to be the judge and the jury and the executioner. Well, guess what? Here in California, the train is going down the tracks of tyranny and totalitarianism, and I'm standing there with my hands up trying to stop it. That's the basis of this lawsuit. I've done many updates for you, and this is all I want to say today, because the hearing where the judge ideally is going to rule in accordance with the law, that is going to be on Thursday, December 1st. Tomorrow, which is November 29th, I'm going to be having my deposition where the Orange County attorney or attorneys will be questioning me about the lawsuit and why I brought it forward and so forth. So that's where we are, friends. I am going to take a look at your comments because I'm very interested to see what you have to say. And for those of you that would like to learn more about this, you can click through to my playlist, and I have done several updates on my lawsuit. So, and I've done several videos about the Orange County Board of Supervisors. So this is why I am doing this battle. There are those that will say, Peggy, you are wasting your time. How do I know that? Because many of you have emailed me. And my question to you is, how do you want me to spend my time? You want me to sit around and watch YouTube videos and get in a frenzy, go on the spin cycle? You want me to do flu mongering and get people all stirred up? You want me to sit around and watch Christmas movies and take my dog for a walk? What would you like me to do? Those of you that oppose my action. What is your action? What action have you taken other than to grumble and complain? That's what I would like to hear. My action matters. Your action matters. I have control over what I do. I have no control over the government. I have no control over the Board of Supervisors. I have no control over the attorneys, and I certainly have no control over the judge. So does that mean I'm going to sit there with my arms crossed and become bitter and angry and complain and point fingers and be a keyboard warrior complaining about people who are taking action? Come on, come on. Action matters. And you don't know which action is going to have the desired result until you take it. Here's why my action matters. Number one, I'm standing up for myself. And guess what? I'm standing up for you. I'm even standing up for that Orange County Board of Supervisors. I'm standing up for their freedom and their rights. And I'm standing for truth. Nothing is more important to me than standing for truth. I will have peace of mind. I will live with self-respect and dignity and integrity, knowing that I did not just give empty threats at that board, shake my fist and yell at them. I actually put my money where my mouth is. I actually brought forth this lawsuit. Frankly, I don't know anyone else who has done so with their local board. Let me know if you know about that. Certainly not in Orange County. And I'm grateful for those that are showing up at these meetings. I think it's important that we do so. I just did a whole video about that prior to this. So I am not denigrating anyone for their action. Each individual takes their own action in a way that is meaningful, relevant, and appropriate for them. This is appropriate for me. I actually don't care what other people think about my action. I only care about what I'm doing, and is that aligned with my principles? Number two, I'm able to educate people through this action. I'm able to tell you what's going on. I'm gaining new knowledge and understanding and experiences. I'm going to be going through a deposition by the Orange County Board of Supervisors, attorneys. That's never happened to me. I'm actually going to be looking at them face to face. I'm going to have an opportunity to tell them of my harm from their actions. I think this is amazing. It is all going on the record. Doesn't that count for anything? It does in my book. So it is important that I'm doing this because I'm educating others along the way. Even the court clerk who is seeing all of the filings going back and forth, perhaps they're being educated. Maybe I'm lighting a flame, or even there's just a little bit of spark of curiosity and interest, such as, oh, I've never seen a lawsuit like this before. What does this really mean? So this is important. It empowers me. It inspires me. It encourages me. And by extension, I hope that it is inspiring, encouraging, and empowering you to not give up, give in, and give over your freedom. I never will. Hashtag never have, never will. I do not comply with anything that is evil. I am here to expose tyranny, to expose oppression, to show you where that train of tyranny and totalitarianism is barreling down the tracks, and I am going to stop in front of it. Whether the train rolls over me or not, I have no control over, but I have control over what I do. I have learned so much about the law in these last few years. I've learned about motions and filings and court procedures. I want to have experiences like this in my life. I want to learn and grow. What am I going to do? Sit around and grumble and point fingers and say, that's a waste of time? That's not me. You know me as a person of action, of positivity, of possibility, of truth, of determination, of perseverance. God granted me those gifts, and I am going to use those gifts with my last God-given, unobstructed. Oh, some of you are going to ask about that. I certainly am not wearing a mask in any meeting. Oh, no way, no how, no sir. And I doubt that they would require that of me. And if they do, I'll do the deposition on the phone or a Zoom or whatever, because I have principles that I'm not going to compromise. That's why I am doing this. So for those of you that are the naysayers, hop on board. See that ship right there? We are sailing. We are sailing to brighter days ahead, smoother sailing. We are sailing toward dignity, respect, integrity, truth, freedom. No tyrant is ever going to steal what's in my soul. I don't care if they do come, I shouldn't say I don't care. Even if they came around with a lock and key for a true lockdown, which we never were in, that's a prison term. I always had a key to my house. Even if they did that, I am going to be free inside my heart, mind, and soul. I live as a free person. I call it living in liberty. I know some of you don't like that word either because you construe it as meaning permission. I like it because of the alliteration. I am living in liberty. My tagline is breathing life back into liberty. And that is why I am doing this lawsuit. I am standing up for you. I am standing up for that board, believe it or not. I'm standing up for that attorney who's going to be deposing me, meaning putting me through the deposition. I am standing up for everyone because God told me to do so. And I really could not do it without you, friends. All sorts of links will be here for you in the description box below. If you would like to support me, if you would like to learn more, please go to my playlist. I've got a list all about the Board of Supervisors. This has been a 2-year battle. I'm not giving up, not giving in, and not giving over my freedom, my dignity, my self-respect, my integrity, and I am standing for truth. All right, friends, I am going to have another follow-up video for you. I do want to share with you what's come into my mailbag from you lovely, healthy Americans. I want to read to you some of the letters that you've sent me because it is such an encouragement to me, and I want you to be encouraged as well. So stay tuned. That will be a sponsored video coming up right after this one, and I will see you in the very next broadcast.